All right, my working capitalist, we have a special guest on the show today. He is Mauricio Rauld. Mauricio is the founder and CEO of Premier Law Group, a premier boutique securities law firm. As a nationally recognized expert on private placements, Mauricio works with elite entrepreneurs who seek to increase and protect their wealth through syndications. Mauricio specializes in Reg D exempt offerings, which we will talk about today, and educates investors from around the world on how to navigate the complex world of security laws. Mauricio, how's it going today?
Oh, it's going good, Jesse, man. Thanks for having me. Appreciate it.
Awesome. I like that the sun is still poking out where you're at right now. Where are you? Where are you talking from today?
I'm in beautiful Southern California, and it's a beautiful day. Except I'm right next door to a couple of fires, and so the smoke drifted over yesterday, and it's still kind of going on here about probably about 20 minutes north of me. So, but just a beautiful Southern California day.
I like it. It's kind of ironic. I was talking with my partner today and we were just like, with all the shutdown stuff, you might just go to California in December and bite the bullet on the quarantine on the way back.
Yeah, for sure. I think California's good. And I used to live in Scottsdale, Arizona. Arizona's a pretty good place to be also in December and January. It's probably in the nice mid 70s, early low 80s in that time.
Sounds great. As we wrap up playing golf, you could get a few more weeks out in Arizona for sure.
You can for sure. Yeah.
Awesome. Well, listen, thank you so much for coming on the show. I thought it'd be really great for listeners to talk with a securities expert. I've heard the term anti-lawyer thrown around. I don't know if that was self-proclaimed, but why don't you give a little bit of a background for our listeners on who you are and what you do?
Yeah, I am kind of the anti-lawyer, primarily because I'm not, you'll find out here, I'm not your typical lawyer. I tend to speak English. One of my dear friends, Tom Mulwright, probably of Rich Dad fame, likes to say I'm one of the few lawyers that actually speaks English. And so my thing is just taking, these kind of complex securities. Just make them sound simple to understand, even though they're incredibly complex. I recognize, and what I'd like your listeners to recognize, especially if they're sponsoring and they're issuing, is it's not your job to know all the little intricacies of the statutes and everything. And that's what the lawyer's for. You're not the technician, you're the quarterback. So your job is to make sure you have a good understanding of everything so you can have intelligent conversations. But look, I've been doing this for 20, 21, 22 years now. Started my career, I went to Cal Berkeley up here in California, and then did what every lawyer dreams of doing, which is I went to work for a pretty large law firm here in Long Beach, California, great firm, did securities work, did basically litigation, did some maritime as well. But I represented all of the brokerage firms, so the JP Morgans, the Merrill Lynch's, the Charles Schwab's, the American Expresses of the world. And so I was in litigation. So when those clients got sued, I'd get brought in, I'd defend them, I'd go to do depositions and motions, trial work, we would do trials, appellates, arbitrations, all that kind of stuff. And then long story short, I realized that's not what I wanted to do. Was fortunate enough to come across the Little Purple Book, the Rich Dad, Poor Dad book, which I'm sure you have read and many of your listeners have read. And just like most of you, it kind of changed my world, made me realize things that I had kind of thought about and knew about, but this was kind of confirmation that what I was thinking was on the right track. And so that led me to meeting the real estate guys, Robin and Russ, who interestingly enough, I was actually driving down Southern California and heard Robert Kiyosaki, a drop-in for the real estate guys. If I had not read that book, literally a couple of weeks after I read it, I heard the radio ad. This is back when we had radios. Tell you how long ago that was. And that led me to a seminar that the real estate guys were putting on. Long story short, I went to work for those guys, was their general counsel, in-house counsel, and did all of their syndication work, securities work back in the day when they were doing a lot of that. And then that kind of led into me creating my own firm and helping a lot of their members. They got a pretty big membership. And so I started helping some of their members, put together syndications and helping them with some asset protection, and started my own firm in 2006, I think it is. So it's been about 14 years now that I've had my own firm. And right now I specialize 100% on syndication because I am a syndication attorney, though that's just a fancy way of saying I'm an SEC lawyer. So I just make sure I help my clients kind of stay out of jail by making sure they're complying with all the securities laws when they're out there raising money from passive investors, like a lot of your listeners.
Right on. Good summary. In terms of securities, I think, at least for me, when I first heard securities as it relates to real estate, I was a little confused. I was like, I always thought that had to do with stocks and placements on, for companies that are in maybe private equity. What is a security for those that don't know, and how does it apply to the real estate world?
Yeah, it's a common question, and I totally get it. Like, why is the SEC involved? I'm just buying real estate. I'm here trying to collect money from people and buying a piece of property. Like, why is the Securities and Exchange Commission in my world? Why do I have to hire a securities lawyer if I'm putting one together? Why do I have to, if I'm a passive investor? The reason is the definition of a security under the SEC is extremely broad. I mean, you're right. You think of securities as stocks and bonds and mutual funds and all that kind of stuff, stock market stuff. But securities are, all of those are actually are definitely securities. But profit sharing agreements, tenants in common agreements, side agreements. I always joke, handshakes, high fives. Those are all securities because the definition of a security essentially is anytime you're sort of taking money from passive investors where the returns are generated by your efforts, you're dealing with a security. So if you're the one actively doing everything and your investors are passive, the structure doesn't matter. You could be doing a LLC, a corporation, a tenants in common, a profit sharing, a handshake. People, it's probably one of the biggest mistakes people make. They try and get creative and like, oh, I'm gonna put this together this way, and that way I'm going to avoid the securities laws because I'm not issuing LLC units or corporate shares or anything like that. And again, it doesn't matter. The structure itself doesn't matter. If you're the one that's doing all the work and generating the return for your passive investors, then you're issuing securities, which is why we need to worry about both federal and state securities laws.
So how do we differentiate if you have a JV relationship, or at least maybe what you think is a JV relationship with, say, 2 or 3 partners? Where do you get to the point where you do cross that line where you need to start thinking about securities and potentially needing exemptions under SEC rules?
Yeah, chapter 1 of the book that I just put out, we talk about that's one of the biggest things. Again, people call, I'm doing a joint venture that I don't have to worry about thing. Again, what you call it doesn't matter. It's how do you actually, what does it look like when you put it together? And the key for a joint venture, if it's a true joint venture, then you're right, it's not a security. But for it to be a joint venture, number one, you've got to have very limited amounts of partners involved. Like you mentioned, 2 or 3, great. If you've got 3 people, 4 people, 5 is about as close as I would get comfortable with, but certainly 2 or 3 people where everyone's bringing something to the table, right? So the returns are not being generated by the efforts of one person, but it's a collective energy of all 3 and all 4 or 5 that are coming together, putting their capital, putting their sweat. Everybody's kind of doing part of the thing, and then that's a joint venture. But what tends to happen is people call it a joint venture, but reality, they need one other person who just needs to put in the money, and they come in and they're not really doing anything, or they give them some honorary title and something that they pretend to do. But again, if it comes down to it, you're going to have to be able to prove that these people did it. And probably one of the biggest misconceptions or the things that people forget about is the joint venture partners better have some real estate experience, right? Because again, if you're like a newbie, or maybe a newbie you can actually get away with because, maybe you're arguing that you're trying to learn. But if you've got a little old lady or something that just writes you a $100,000 check and they don't know the first thing about real estate, it gets harder and harder to argue that they're bringing some expertise and something to the table. I'm not saying you can't do it, but you really want to make sure that they're actively involved. That's the key. Everybody needs to be actively involved, and not equally. I mean, it's proportionate, right? I mean, I may only put in 10% of the money, and maybe I'm only doing 10% of the work. That's fine. But if I'm putting in 10% of the money and I'm getting paid disproportionately from everybody else because I'm doing 90% of the work, that's going to start to look a lot more like a security.
So once you determine that you do have a security, or you think that you have a security, I think I've heard you talk before, you have the option of registering it, which nobody does, or very, very few people do, or they start looking for exemptions. So maybe you could talk about, those two, the differentiation between the two, and then if they do go that exemption route, what that looks like.
Yeah, I would say there's 3 actually. So you can register the security with the SEC, you can find an exemption, or it's illegal. It's one of those 3.
Yeah, you got 3 options.
So registration is basically going public. When we say registration, we're talking about a full-blown IPO, and that's something that just takes years and it costs 7 figures, 8 figures. I mean, it's just not something we're going to be doing, especially if we're real estate investors, right? We're typically going under contract, and we've got 60, 90 days to close. You don't have time to go file your offering with the SEC and spend $1 million. I mean, this makes no sense, right? So, and we obviously don't want to do anything illegal. So we're always looking for exemptions, right? Which is where I live. I live in the world of exemptions because everybody is going to find an exemption. And there's really 2 exemptions that 95, well, it's really one exemption that probably 90% of the people use. And then there's another one where it kind of covers now 95% of the people. And these are the infamous Reg D exemption, Regulation D. So anytime you hear about Reg D or maybe 506B, 506C, and I promise that's probably as technical as we're going to get, but those are exemptions. And so the idea is we don't want to register our offering with the SEC, so we need to find an exemption, and most people will pick either a Rule 506B or a Rule 506C, and those two rules are part of this Reg D exempt framework. And that's really where I spend most of my time. I think in my practice, I would say, probably 2/3 to 70%. I'm kind of making this up. It's just really, it's not like I'm looking at statistics here, but about 2/3 of my clients will do 506Bs, which we can get to in a second. But essentially that means that you cannot advertise, but you can take some non-accredited investors, which I know we'll talk about in a second. And then the other third will do a 506C, which is not a relative, I guess it's been 7 years now, but I'm going to call it a relatively new exemption that actually allows you to advertise, which is kind of like the appeal of it. It's like I can go and do podcasts and talk about my offering on a podcast or at an event or on Facebook or whatever, but I'm limited to accredited investors only, and there's some verification requirements on the issuer's behalf. But that's where I live. I just make sure that we're complying. And the reason these are popular, by the way, Jesse, because I think it's important, is these are preempt state law. So just imagine, as you know, we've got 50 states, and if you can imagine that you're putting together a deal and you have investors from 7 or 8 different states. If we didn't have this preemption thing, which basically means the federal rules trump, and we don't, no pun intended, the federal rules trump the state rules, so we don't usually worry about the state securities laws other than the anti-fraud provisions. If we didn't have that preemption, we would have to go literally not only hire an attorney in every single of those 7 or 8 states, but even hire, so that's time and expense, but then we've got to make sure that our offering fits in within 7 or 8 different statutes, and every statute in every state is slightly different. So maybe one offering works in this state, but it doesn't work in this other one, so we got to tweak it, and then now it doesn't work in the third. It's a nightmare. So 506B and 506C tells us we don't have to worry about all that nonsense, and we just worry about the federal rules. And if we comply with 506B, these terms, then not only are we assured of being in compliance with the rules, because they're what we call safe harbors, but then I don't have to go hire a lawyer in every single state and make sure that we're compliant with California law, Florida law, Texas law. We just worry about the feds.
So I was always curious because, real estate is where we live, but real estate is not the only industry that raises capital. And these exemptions, are these exemptions particular to real estate, or, in the movie industry that's raising capital, will they use these 506C, 506B exemptions as well?
Yeah, this is not, it's not specific to real estate. It's interesting, actually. So I go as an attorney, we're just like a lot of other professions, we're required to keep up some amount of hours every 2 or 3 years from education. So I obviously go to these conferences with securities rules. And the attorneys up there and the panelists, they have very little idea about real estate. Like their world is not real estate. Like, I'm actually, when I chit chat with them, I'm kind of an expert in there. I could certainly be up on that panel talking about the real estate piece, because their clients are usually startups, right? That they, it's a company that needs, think of Facebook. I always like to give the Facebook example. Obviously now they're public, but think of Facebook when it just started, after the first round of funding or whatever, they got a little bit of money and they started to grow. And then suddenly I need another $1 million or $5 million. I don't even know how much they were raising. They went out there and just did a private offering. And I don't know what exemption they relied on, but it back then it would have been a Reg D most likely. And they're just raising capital for their operations. And so you could have a brewery that you want to expand and you want to add another whatever. I mean, you can do it for anything. A movie is another great example. These are all the same. Actually, I did way back when I did something relating to a movie, and it was a 506B. So it's not real estate specific.
So when you're raising that money, just kind of made me think about startups. And a lot of times, friends and family are the first investors that really give the seed capital, and not dissimilar from real estate. A lot of times the first investments you do are with that close circle. So maybe we could talk a little bit about the exemptions and what type of carve-outs, if any, there are for family and friends as opposed to accredited investors.
Yeah, I mean, one of the reasons 506B is so popular, and I think the last statistic I saw is that between B and C, I think 90% of people use B over C, is because you can accept non-accredited investors. And usually when you start out with friends and family, it's like Aunt Jenny and Uncle Bob and whatever, and they're not accredited. They're not high net worth individuals. Not
always rich Uncle Bob.
It's not usually rich Uncle Bob. And so that's why this is kind of such an appealing exemption. And so you're allowed a limited number of non-accredited, so which is 35, which usually most of the time, especially if you're raising $1 million, $2 million, you're usually not going to have an issue of running up to that 35 number. But an accredited investor is anyone who has $1 million in net worth, excluding their primary residence, or has earned $200,000 the last couple of years, meaning now 2018, 2019, with a reasonable expectation of earning that much or more this year. They're actually expanding that definition a little bit, and I can go into that if you want. It just literally came out just over 2 months ago, which, what is it now, the 28th? So it probably is in effect right now, but they're actually trying to expand that definition. There's been a lot of just debate as to whether, net worth or income really should be the test as to whether somebody should be able to invest in some of these investments. I mean, there's plenty of really, rich folks who are complete morons and shouldn't be investing in this stuff. And there's a lot of people with modest means who are the smartest people in the room. So they're starting to expand that a little bit, and they're going to start allowing some certifications, meaning if you want to go take the time to go take a course and pass an exam and get a certification, then that you've studied this thing and you know what you're doing, then you will become an accredited investor, even though you don't qualify via the income and net worth. So that's going to be interesting. We don't know exactly what that's going to look like. It literally, like I said, came out 2 months ago, and they're just starting to roll out some of these programs. So we don't know who's going to be given certification licenses. Is this going to be a weekend seminar? Is it going to be a semester course? Is it a 5-year program? I doubt. Hopefully it's a weekend course or something that you just take for a couple of days and then you take an exam and you're done. But yeah, so 506B allows you to take up to 35 non-accredited investors, which is why it's appealing. The big drawback, and it's appealing because you can raise an unlimited amount of money too, by the way. So I always used to say JP Morgan had a $2 billion real estate fund, but I just saw that, I think earlier this year, Blackstone, one of the largest hedge funds out there, they have a $26 billion real estate fund, and that was a Reg D offering, a 506B.
Wow.
Now, they stick to accrediteds only, and they use broker-dealers. I mean, they play at a whole different level, but it's a 506B exempt offering. So unlimited amount of money, up to 35 non-accredited, which is nice. You get the safe harbor, so you don't have to worry about the states. The preemption, so you don't have to worry about the states. The big knock on 506B, the big limitation is you're not allowed to advertise, right? You can't go on Facebook. We can't go on this I can't come on your podcast like, hey, Jesse, I've got a deal. I'm looking to raise $1 million. If anybody's interested, give me a call. That wouldn't work. I can't go on Facebook. I can't do Facebook ads or post on Facebook. I can't go to a conference. Not that anybody's going to conferences. I can't go to a conference, start passing out my business plan. That's a general solicitation. So that's really the restrictive part of it, because it's really supposed to be a private offering. You're supposed to be going to people you already know, people you have what we call pre-existing substantive relationships with them. And so advertising is public, right? That's never been a part of it. And then in 2013, on September 21st, they passed this 506C. This happened right after the financial crisis. Remember, 2008, 2009, 2010 was a disaster. And so they wanted to sort of encourage people to go raise more capital, because if you remember the financial crisis, everything had really tightened up. So in 2012, the Jobs Act passed. And then in 2013, 506C came along, which actually allows you, it's basically the same exemption, except it allows you to advertise, which is the big pivot, right, for the first time. And even though it's technically a private offering, you're allowed to advertise, which is kind of a weird thing. And your only real restriction is that you have to limit yourself to accepting accredited investors only, and you must take what's called reasonable steps to verify that they're accredited. I can't just take their word for it. I can't, Jesse can't just give me a questionnaire and check a box and say, hey, I'm loaded, I'm good. I'm going to have to I'm going to have to look at your tax return. I'm going to have to get a CPA letter, just something that shows that I've taken some steps to verify accreditation status. And so that's, we thought that was going to really take off and really be an exemption that a lot of people would use. But honestly, it hasn't, the statistics show, 90-10 right now in terms of B versus C. But I always encourage clients. It's a lot cleaner, I think, to do a 506C. When you deal with accredited investors only, right or wrong, you typically have less issues, because the law, again, assumes that the accredited investors know what they're doing. They don't need protection. And so there's less requirements in terms of disclosures, and, they're just big boys and big girls. And so it's harder, I think, to get into trouble if you're only dealing with accredited investors. When you bring in non-accredited investors under a 506B, now everything changes, and you've got to literally treat them like they're the little old lady, the widow, the 95 years old, that kind of thing. And you really want to treat them with white gloves and put together huge documents, disclosure documents, laying it all out in as plain English as you can to make sure they understand all the risks involved with the investment.
So I'm assuming the last offering I looked at, which was about a month ago, I'm assuming it was a 506 506C in that we were given, like you said, that questionnaire of, do you have $200,000? Are you expecting to make it? I think, like you said, $1 million in marketable securities or cash. And then I think it said 5 million in real estate assets, something to that effect. But that would be, I would assume that is not enough to verify from the sponsor's point of view.
Yeah, not under a C. If it was a 506B, that would be enough. On a 506B, we would just send out the questionnaire. You would check the box. You would make a representation. And as long as I know that otherwise, I mean, obviously, if it's a homeless guy and you know they're not accredited, that's not going to fly. But if you have a reasonable belief and the questionnaire works, but if you're going to do a 506C, then look, most people outsource that. It's just kind of a pain. But essentially, they're going to look at tax. If it's income, they're going to look at W-2s. They're going to look at tax returns, 1099s. If it's net worth, they're going to look at assets. They're going to look at your liabilities. They're going to pull a credit report. They're going to ask for you to make a statement saying I don't have any other liabilities outside of the ones I've listed and the ones on my credit report. And the easiest way is actually the easiest one that you try and get is a CPA verification letter. So if you're a CPA, obviously, that the CPA does your taxes, they're familiar with your financials. If they write the proper letter with the proper language, that letter alone can suffice. The issue is, I know there's a lot of pushback with CPAs because the reason we can get CPA letters is it kind of pushes the liability onto them, and they don't want the liability. So they don't want to be making these statements that, it's like they always want to, kind of backpedal a little bit and just be like, hey, I'm not guaranteeing anything. It looks like they're accredited. It's like, I don't know. And it's like, no, we need you to. The reason it works is because you're a licensed person. And so if you are wrong, I can come after you. And so there's a lot of liability pushback. So at the end of the day, a lot of people just use the tax returns because that tends to show, the information that you need.
Rather than, a reliance letter, I guess. In terms of so you see a lot in the news, and I think it was Cardone Capital recently. I believe it was a class action lawsuit, or is a class action lawsuit. Yeah. And I was always a little perplexed because, I mean, I think most people listening are aware of who Grant Cardone is. I mean, you can't really go anywhere online in real estate without bumping into him. So when he was doing these offerings, some of the things he would say were just sounded very, very, I guess, didn't take a little bit of a creative license in how much your returns are going to be. So maybe if you know kind of what that type of exemption, or as far as I understand right now, he's even going to actually not going the exempt route and registering some of his. So what are your thoughts on that? Yeah,
so Grant uses another exemption. So the one that not too many people use, which is a Reg A. You may have heard of Reg A. So there's Reg D, which we just talked about. And then there's a Reg A, which is kind of, you do register. It's kind of, we call it the mini IPO, because even though it's not a full-blown registration, there is a registration process and an approval that you have to get from the SEC. So you submit your documents to the SEC, and then you spend the next 6 months or so going back and forth with the attorney, and the attorney wants you to fix the docs and put more disclosures or ask you questions, and they're kind of doing due diligence on you. And then after a 6-month process, they come back and say, they kind of give their stamp of approval and say, okay, these documents are good to go. Now you can go offer it to the public. And the nice thing about Reg A is that not only can you advertise like Grant does, but you can take non-accredited investors. So you get the best of both worlds. Most of the time you're taking smaller amounts, but if you watch Grant, you'll see that he was taking $5,000, $1,000. I don't know if he had a minimum. He was just taking money, and he was advertising. But he could basically hit as many non-accredited as he wanted up until I think 2000. But I don't think he had 2000. The only limitation really for non-accredited is that they couldn't put in more than 10% of their net worth or income, whatever is highest. So it's a lot of flexibility. It doesn't work for most of us because, again, most of us, we have 60, 90, 120 days to close, and this is going to take 6 months plus. So, but if you're putting together a fund, which is what Grant was doing, you could do that. So the issue with Grant is not that he's entitled to advertise, because that's a big issue for us in 506Bs. People are out there doing this wrong all the time. They're advertising without even knowing it. They're on Facebook, and you're like, dude, that's advertising. You're violating the rules. Grant can totally do that. Where Grant allegedly is running into trouble, because again, this is just a complaint. It's just a bunch of people that are not happy with the returns they're getting, and they hired a lawyer and complained. So these are just allegations. That is that the issue there is the anti-fraud provisions, actually. So even though you're allowed to advertise, you can't misrepresent what you say in an ad. You can't make an omission that makes the statement untrue because you kind of didn't fill in the blanks. And so I think one of the biggest ones that I remember reading in the complaint is he was kind of doing these blue sky. He was really promising the world, right? Hey, I'm going to give you 15% annualized returns. I'm going to triple your money in 2 years. Like all these statements that the allegation is that he had no real basis for making those. I mean, this was a fund actually where he didn't have any properties when he sold this thing. So like, where do you come up with a 15% return when you don't even know what you're buying yet? Like, how can you say you're going to triple our money? And I think one of the issues was that when he filed it with the SEC, he tried to put that in the docs, and the SEC said, no, you got to take this 15% out. Well, that's the allegation. And so when he took it out, great, but then he's advertising and doing the 15%. So that the lesson for me, again, whether this is true or not, and it turns out to be true or not, is that even though you have the ability to advertise on Facebook, on a podcast, on whatever, that doesn't mean you can do whatever you want. There's still parameters. You don't want to go crazy. You don't want to be promising the moon. You want to be putting all these disclosures and disclaimers in there, which you don't really have. If you're doing a Twitter post, you don't have room for those long disclaimer things, right? And even on a Facebook post, although you can get a little bit more room, what you want to do on if you are allowed to advertise, whether it's a 506c, whether it's a Reg A, whether it's some other ones, you want to get them off of there, right? You want to put an ad in there or a post where there's a link or something that takes you to a landing page or somewhere else that you now have much more control over, and you can throw in all your disclaimers. Hey, this is an unregistered offering. This is only for accredited investors. Past performance is no guarantee. Like all those disclaimers that you've seen before. But that was Grant's issue, is he was relying on Reg A, which if you're doing a fund works well. It's super expensive. Super expensive. It's much more expensive to put one of those together than a regular Reg D. And there's all the compliance that goes along with it. Just like public companies have, quarterly reports and annual reports, they're not as onerous, but there's definitely a lot of reports and audited financials that you got to put together. So you really got to be raising 50 million or something for that to really start making some sense.
Okay, that makes sense. I bet he's a lawyer's dream having that much online content for discovery. So, I have a kind of meetup I do once a month for cross-border investors. Some of the guys and gals are Canadian, some are US, and I'm sure there are listeners that have a very similar thing going on. You talked about something, you said substantive prior relationship. At what point does the SEC legitimately see a substantive relationship or not? And, how do you kind of navigate that?
Yep, great question. I did detect a little bit of a Canadian accent there in some of your vowels. So I talk about this I think this is chapter 3 of the book. So when the easiest way, it's not the only way, but the easiest way, we talked about 506B, you're not allowed to advertise. The easiest way to prove, because it's your burden, that you did not advertise is by having what we call a substantive relationship, a pre-existing substantive relationship with your investor. And luckily for us, this is one of the few areas of the law or in the securities world that we actually have some pretty good guidance. They've actually come out with a list of things that you should be doing in order to establish that relationship, where you take a complete stranger that you've never met. You go to a meetup, for example. I go to your event and I meet Joe and we exchange business cards. Great. I don't know Joe from Adam, but now there's a roadmap that I can follow where if I take there's actually 8 steps that they recommend, not that everybody does all of them, but good practice would be to try and do as many, if not all of them, where I can take a complete stranger and walk them through to a point where I have a substantive relationship. And basically a substantive relationship is just, you've gotten to know them well enough that you believe that they have the sufficient knowledge and the expertise in sort of business and financial matters where they can properly evaluate the risks and the merits of the investment. So it's really a back and forth. Your SEC really wants you to foster that relationship. So it's getting on a phone call, maybe multiple phone calls. We typically recommend this because it's one of the big 2, which is to send out a really detailed questionnaire that I've put together if you guys are interested in seeing that. But, it usually starts with a questionnaire, right? Here's your questionnaire. And it's not just like, hey, what's your name and what's your favorite color? It's, what's your net worth? What's your income? What are your goals? What's your experience? Have you invested before in private offerings? Are you a growth minded? Kind of that same thing that if you're filling out an options agreement or something, if you want to invest in stocks. And that's usually probably step 1. And then you get on a phone call with them and you're probably talking through that questionnaire and you're encouraging them to look at your website. You're encouraging them to ask you questions. And again, there's no magic timeline. The SEC has been very clear that it's not 30 days or what we used to be called a 3-touch rule and all these things that used to maybe be now. But now it's like, it's the quality of the interactions that really matters, right? But at some point you're documenting this information. And at some point you say, you know what? I've known Jesse now, and there's no magic. It could be a week or 2 months, but I've known Jesse now a few times. We've spoken on the phone. We've been emailing back and forth. I've shown him some of our prior deals. I understand what he knows. He's a smart guy. I get it. I've documented all that. All right. Today is the day that I I hereby declare that today is the day that I have a substantive relationship with Jesse. Now I can offer Jesse a future deal. I still can't offer him any current deal because I have to have a pre-existing substantive relationship, and that means pre-existing the offering. So anything I've got now, you're not eligible. But if next quarter or next year or next month I have another offering and I want to do a 506B, I could come to you, and because now I have a substantive relationship with you, and offer you that deal.
So let me give you a case study. We had somebody on the podcast that prior to being a syndicator, he was in law enforcement. When he left law enforcement, one of the things he did was, he had talked with his colleagues over, I guess, months, if not years, about the real estate investing he was doing. And then when he eventually left the force, he said, listen, guys, I'm going to have a chat about something that I'm looking at right now, real estate investment, things that I'll look at in the future. And, whether it was 20, 25 guys that he had known for a number of years. And he had talked about, raising capital for a particular property. At that point, do you think the SEC would see that as a substantive pre-existing relationship, that they were colleagues, they had talked about real estate, or would he need to do more in that scenario?
No, I think, this is all, the key words for us is always, they're all facts and circumstances. You'll always hear those things, right? So they're all unique things. But I think, again, the rule says that you cannot advertise and you cannot generally solicit. It doesn't say anything about you have to have a pre-existing relationship. In fact, if you get a referral, right? If Jesse, you've got a deal and I've got my brother and I'm like, hey, Jesse, meet my brother. He's looking to put money on. I know you've got a deal. You guys connect and he invests in your deal. You don't have a pre-existing relationship with my brother, but you didn't advertise either, right? You didn't generally solicit. So I think in those scenarios, in your case study, if you've got somebody who's having sort of a closed group, I don't know if they were one-on-one calls, if they were getting together at a dinner, or I don't know how he was communicating, but if he had this long, many years and met them up, clearly he was not clearly he did not get those potential investors via advertising and generally. So he had a relationship with a pretty good one, a friendship actually, and a business relationship with them. So I think that's how you get around that one in terms of I did not advertise or generally solicit to these 25 people. Now, if those 25 people are just, I think the dangerous part is when you just get on a mass mailing list. And now they're part of 10,000 people. You're just going to blast, and you don't really know those people. That's where you're going to get more of an issue. So to me, the pre-existing always is really the tool that we use. Is when you just met somebody, like you don't know them at all. You met them at an event, or maybe you used Facebook the right way. Maybe you put a really great series or something on Facebook that was not advertising, was not soliciting, but somehow you got their email, a lead magnet or something, and now you've got their contact information. That's the kind of person you want to start putting them through that process. If it's somebody you've known for 20 years, clearly you did not advertise when you had those conversations with that person about a particular deal.
Yeah. So you mentioned radio before and said it dated you. I consider myself a senior citizen in the millennial world. But my point is that technology is shifting and it's moving fast. And I think I am fairly savvy technologically. I'm, online trying to put out content for real estate. You had a podcast where you talked a little bit about what you should be doing, when you're online. And I think it was to the effect of, when you're raising for a deal, post your family, post your friends, do fun stuff, but maybe not real estate, especially specifics to the deal. And then when you're not raising capital for something, talk about education and real estate. Maybe you could talk a little bit of that best practice and, what the implications are for the future. Because at the end of the day, I think that we're not going to get younger real estate guys or gals to be off social media. They're going to use social media. But what are, from a lawyer's point of view, what's the best practice for them?
One of the frustrating things for us, and it's a legitimate frustration, is, social media is relatively new. I mean, it's been around now for a little bit, but you should think about it, back in 2008, which is the last big financial recession crisis we had, Facebook was around, obviously Twitter was around, but it wasn't at the level that we have it now. And so the issue we have is that everything's been going so great for the last 12 years that we haven't really had any challenges. We haven't really had any issues come up or really the SEC nailing anybody for stuff they're doing. So we don't have that much guidance. But Facebook and all that's if you're putting something about your deal, that's advertising. And the key term or the thing to understand is that there's a concept called conditioning the market. So obviously, if you have a deal and you're not allowed to advertise, you can't post that on Facebook. Everybody kind of gets that. But even if you don't talk about your deal, but you're kind of, anything that gets people excited about what you're doing, or maybe you're talking about your prior deals, and it's just a way to arouse people's enthusiasm about what you're doing. That could be conditioning the market. And so I've always recommended that if you have an active deal, if you're a sponsor and you're doing a 506B deal, meaning you're not allowed to advertise, then just stay off social media while you have that active deal. I just think you're playing with fire. Is it possible for you to post something? Yeah, but it's such open for interpretation. Like, why run the risk, right? Plus, that's not the time to do it. I mean, the time to find investors, it's a long period. It's not something you just kind of put on a switch and suddenly 20 people sign up for your deal. It's going to take a while. And so I recommend that there's two things we know we can put on Facebook or on social media in general. Is one is factual information about yourself and the company. So you put your resume up there and brag about what you do and what your company does and what your level of expertise is. And then the other thing is value add. So there's nothing wrong with putting together content that people really find valuable, that they were willing to exchange their phone number or their email address in exchange for that content. So putting together a report as to why real estate is the greatest asset class for building wealth, and it's just a report on that, and you get somebody's email in exchange for that report, great. Why Southern California is the greatest real estate market of all times to invest in right now, or why mobile home parks is a great asset class. All those kind of things are what you're doing. I mean, you're a great, I don't know if you're doing 506Bs or Cs or whatever, but podcasters is a great thing, because if you notice, you're adding a tremendous amount of value to your audience. You're interviewing a guest, or you're talking about real estate. You're not talking about your deal. You're not talking about anything. And if you're entering your podcast, you said, hey, well, by the way, I put together, I have a book. If you want a copy of my book, email me, or I've got a webinar series, or if somehow you get their contact information, that's totally legit. And that's how you should be leveraging social media when you don't have a deal, getting to go to as many webinars that you can, or especially now they're all virtual meetups, or go to meetups that you're putting together, get into contacts, and then put them through those 8 steps so that you can take them from a complete stranger and get to a substantive relationship so that you can offer them a future deal.
Yeah, it seems to be the funnel that just investors have just gravitated towards over the past few years. One thing I was curious about if you had any stats on the private placement market. I've always been curious, and it's been very hard to find online, as to, number one, whether we know the size of the private placement market, say in the US, and then secondly, what the average deal size is. I think most people think that these deals on average are tens of millions of dollars, and I don't think that's close to accurate.
No, I do have, I haven't looked at them in a while, but you can find them if you Google around. I was actually looking for that information last year, and I came across 2017 numbers, and maybe now I don't remember where they came from. I mean, they're SEC, but I'll give you some of the answers. Number one is the average raise, according to the SEC, is 1.2 million. So take that for what it's worth. I got clients or prospects that say, it's a small raise. I'm only raising $1.5 million or 2 million. I'm like, the average is 1.2. So that's just a number that I've seen out there. And then what I saw, which I thought was interesting, is in 2017, there were something like 30 to 35,000 private offerings, 30 to 35,000, which is a big number. Only 8% of those had non-accredited investors. Because even when you do 506Bs, well, most people equate as 506Bs with non-accredited. The reality is, outside of real estate, a lot of people are nervous about raising capital from non-accredited investors. Certainly if you're a big company and you're going through a broker like Merrill Lynch or Goldman Sachs, and they have these high net worth limits, you're not going with non-accredited. But the level of disclosures for non-accredited is really tricky. And most attorneys, I think, and most issues would probably recommend not to take non-accredited, because if you're just raising capital for your deal, for your business, I think, there's a group of us that do the real estate piece that we know the real estate asset class well enough, and it's very similar. A multifamily is a multifamily. Yes, there's specifics about your particular deal, your particular market, but 90% of those risks are probably shared among all multifamily investors, and they're shared among all the mobile home park investors. But yeah, 8% of that 30,000. I was trying to figure out, just for my business, like how many 506B, non-accredited kind of deals were out there. Or actually, that's not what. I'm sorry, I'll take it back. What I was trying to figure out is how many issuers, how many people are doing this. That was what I was really trying to figure out. Like, how many people are out there raising capital? Is it 1,000 people? Is it 5,000 people? I mean, because I was actually talking to somebody and we were talking about marketing, and I'm like, well, why don't we just do this and this and this? And they're like, I don't know if there's that many people raising capital. I mean, there's not 10,000 people.
Yeah.
I don't think raising capital. So anyway, I thought that was interesting to stick. But if you Google around, you'll if you dig in a little bit, you can find it. And I'll look at, I don't know if I saved any of it, but I'm happy to forward that to you if I dig it up.
Yeah, that's fascinating. I've never really thought of it from the business development side for the lawyers, so where, that's your pool of clientele that you're kind of going after.
Yeah, because I got into the whole sort of, Facebook marketing and, the geo-fencing, which I know you're familiar with. So every time I went to an event, I would just kind of capture that whole event. And then I'm like, well, why don't I just extend that to something else? Maybe I'll do that. And then and I'm just kind of running numbers. And then I'm like, wait a minute. I may already know everyone. I may already know, there may only be 2,000 or 3,000 people who are doing what we're doing. Think about it. Those 30,000 was everything. That's not just real estate. That's all of it. So what percentage of that is real estate? I don't know. So how many real estate syndicators are out there was really what I was trying to get to. Like just have an idea of what the market, what that market looked like. And I still don't have an answer to that, but that's how I found those stats.
So, we have a little bit of time left, but before we wrap up, I wanted to talk about something about crowdfunding. And, we've heard so much about this over the last few years. What are your thoughts on crowdfunding and how do they get around? You mentioned Grant Cardone raising 5,000 or 2,000. When you see crowdfunding, where do they play in? Is it the exempt pool? And what would a lawyer like yourself do for a company that is raising via crowdfunding for real estate?
So when you say crowdfunding, there's two things that pop into my mind. One of them is a 506C deal. A 506C deal is crowdfunding, really. I used to call it the big C and the little c. So the big C was crowdfunding. 506Cs, that's where people started doing their stuff, and they would put their ads on their websites or whatever. Then there's another exemption that came out not too long ago, actually, maybe 3 or 4 years ago, which is called regulated crowdfunding, which is really the real crowdfunding. But that limits you to $1 million. You've got to use a particular portal. You can't use your own website. You're very limited on how you basically you're trying to drive traffic to that website. And those guys are really investing $50 or $100 or $500, right? So I'm like, do you really want to be, do you want to be dealing with investors who are giving you a $500 check, and end up with 1,000 investors or something? So I'm not saying that's not something you could do, but that's what you're dealing with in that world. I don't have any issues with crowd. Now, again, Grant started doing 506Cs. So if you remember or you think about it,
those were the big raises, right? He did.
It was like 250 minimum. There were accredited investors only, high net worth, 250 minimum. And then he did such a great job building his audience. He's like, well, wait a minute, I've got all these people watching me, and they don't have 250 grand. They have 5,000 or 1,000 or 2,000 or whatever, 10,000. And so that's when he did the Reg A, because he had the time to wait 6 months, 8 months. I think with him, it took him a little longer. He's a well-known guy. So I think it took him a little bit longer. But once it got approved, now he can use that platform that he's developed and worked so hard for over the last 2 or 3 years and capitalized on it. And I think that was genius. I think that the issue with Grant is just he's a marketer and he gets excited and can't contain himself.
Yeah. Triple the returns. So Mauricio, we do some similar questions for all the guests, and we're going to do those quickly here, try to go through them fairly expediently. And then I want to talk a little bit about where people can reach you, and especially your book, which I love the title so much. We might have to name this podcast episode the title of your book. So number one, you talked a bit about how you got into real estate and Rob Kiyosaki. But are there any other mentors that you had early on in your career, whether that was people that you knew or just authors, people in the industry that put you on the path that you're on and have been doing over the last few years?
Yeah, I think the one that comes out right away is a gentleman by the name of Jim Rohn. I don't know if you guys have heard of Jim.
Love Jim Rohn.
And I actually found Jim through Tony Robbins. So Tony Robbins is a disciple of Jim. He actually worked for Jim when he was like 18 years old. So I started with kind of Tony Robbins. That's how I got into the whole personal development thing. And then I discovered, thanks to the real estate guys, because they were really into it with Jim. So if you haven't heard of Jim Rohn, ROHN, I highly recommend looking up. So I've learned a ton from him, and I definitely consider. I never met the guy. He unfortunately passed away about 10 years ago now. But he has such amazing success principles. And Darren Hardy's another great guy that he's also now basically took Jim's reins. And now, so if you've heard of Darren, he basically, it's all Jim Rohn stuff. So if you actually listen to Tony Robbins or Darren, you'll just hear these sayings and principles. And it's all Jim Rohn stuff. So that's by far probably the number one mentor. And then I do want to say the real estate guys also, because that's right at the beginning of my investing career and all that stuff. They, working for them, and obviously known them now for 16 years or something, and good friends of mine. But they've taught me quite a bit as well. So those are kind of the mentors on the business side.
Yeah, those are good answers. It's funny how this industry in general, even investing, Jim Rohn, Zig Ziglar, Tony Robbins, it seems like very common interests. And Jim was definitely one of the top guys. In terms of some of the books that you have read, whether it's specific to the law industry or real estate or business in general.
Yeah. So I think The One Thing is one of my favorites. Talks a lot about focus and how everything, and Darren Hardy and Jim Rohn talked about this all the time as well. It's like, everything isn't equal. If you have 100 things on your list, there's only a few things that make the most difference. And that's kind of what The One Thing really focuses on. There's another great book called Traction by Gina Wickman. It's more of a business, kind of how to start or really build an organization. So if you're a business owner and you're looking to sort of scale and put systems in place, that's a great one. And then The E-Myth is another great book that talks about, working on your business as opposed to working in your business, which is what most people have a job. They create a business, but they're really just working in it. So The E-Myth is great. And I'm fortunate enough to have, or I don't know where it is, but there's an E-Myth for attorneys specifically. So I've read that. That obviously doesn't. But I think those three, The E-Myth, Traction, and The One Thing are probably the three books that I would recommend the most.
Okay, two more hard
ones. I'm sure I've missed them. I know there's others that I could probably rattle off 4 or 5 more that I'm like, oh crap, I left that one out. Rich Dad Poor Dad would be probably, I should,
Yeah, that should just be mandatory reading for kids.
Yeah.
So in terms of something that you wish you knew at the beginning of your career that you know now?
I wish I knew about real estate earlier and just start. Like the best time to start real estate is 20 years ago. As Robert likes to say, the best time to start to invest in real estate was 20 years ago. And then next best time is today, I wish that I've been sort of brought up with that. I got into the game a little bit later than most. I didn't really buy my first property till I was in my 30s. So it would have been nice I'm in the personal development world. I see a lot of my friends or people who bring their like 17, 18-year-old kids to these seminars and this stuff. I'm like, wow, that would be, I got 16, 17-year-old kids that are buying their first property thanks to their parents. So that's something I would have liked to have done earlier. And had I known that back then, I would have started a lot earlier.
That's great. Now, my personal favorite, first car, make, and model.
The first car I ever had was, you'll love this, was a Hyundai Excel.
Boom.
And this was when Hyundai just came out. So this wasn't like if I don't even know if you think of Hyundai now, it's whatever. It's a normal. When it came
it's
out,
a normal car.
It was like a Pinto.
Yeah.
Like that thing was like made out of tin, like a tin foil or something. It was actually my dad. I shouldn't complain. It was my dad's car. It was a hand-me-down when I went to college. But that was my first car. It was a stick shift too, a Hyundai Excel.
Yeah, well, who was it? I don't know if it was Bloomberg or Econ Talks at one of the podcasts I listened to that said it's a millennial security device having a stick car these days.
I know, right?
It's a feature.
Yeah, no, it's. I think it did have hydraulics, but it was I think the car brand new was like $6,000 or something.
I really need to catalog these. We've had some pretty unbelievable cars over the last few months. Yeah. So Mauricio, first, let's talk a little bit about the book. First of all, the title of the book is fantastic. Maybe you could talk a little bit about where people can get it and what your goal was in writing it.
Yeah, and it's an ebook, and I think I'm going to keep expanding it, and maybe eventually I'll turn it into like a hardcover. But it's called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And it started with like I was doing a lot of content about the 3 biggest mistakes, and I think originally I wanted to do sort of the 3 biggest mistakes, and then I just kind of found more and more things to talk about, and then I figured the 5 things is a good number because it also gives me pretty much anything we talk about. I can sort of point towards one of those chapters because I think that kind of encompasses everything. So I started writing that at the end of last year. It took me forever to finish it, and then finally finished it. I think literally like in July or August of this year, and finally got it. Again, it's just an ebook, but I think it gives everybody a good primer of not only the things that a syndicator should realize not to do, but also some guidance as to what to do. I believe strongly in, you want better answers, you just got to ask better questions, right? World-class answers require world-class questions. So the better question is, how do I do something? Not I can't do this, I can't do that. How do I do this? How can I pull this off? How can I accomplish this? And so I give some tips in there. Joint ventures are a great example. Like, how do I put together a deal so it is a joint venture legitimately as opposed to security? How do I market on Facebook so I can do it legally? So that's kind of the thing. But so 5 things every syndicator must know to stay out of jail, and happy to share that with anyone.
I'm curious if it's just a personal question on the writing of the book. How long did you think about writing a book before you actually put pen to paper?
I've been thinking about it for a long time, and I'm not even sure that's I always wanted to write a syndication book. And that's where I started, but I envision this book sort of evolving. Look, there's a lot of regs that just came out in the last month that if they pass will make one of the chapters obsolete. So I got to go back there and rebuild it.
Yeah.
And the nice thing about ebooks is, I don't have to wait for a second edition or a third edition. I can literally come up with an idea and be like, oh, wait a minute, let me add that to my ebook. I can put it in there. I can automatically put it back in there, and it's done. So that's kind of my goal, is to keep going. But I've been thinking about it for a very long time. I think books in general are just great, not only to show your level of expertise, obviously, although in these days you can do, social media and YouTube. I mean, we've all got YouTube channels. But just from a marketing standpoint, I think it's great. It's like a business card. I use it as a business card. So instead of handing somebody a business card, you hand over a book. That's really one of the main things I looked into it.
For sure. Mauricio, where can people find you online aside from your regular Google search?
Yeah, so if you go, my YouTube channel, just Mauricio Rauld on YouTube. I try and put as much content as I can there. A lot of videos there. Website's premierlawgroup.net. And if you want a copy of the book, just email jail@premierlawgroup.net, and that'll automatically send you a copy of the 5 things every syndicator must know to stay out of jail. And I did just get the URL, stayoutofjail.com. But that's not set up yet. That'll be up and running pretty soon. But jail@premierlawgroup.net, and that'll come to me too, an email. So that's a good way to get a hold of me as well.
My guest today has been Mauricio Rauld. Mauricio, thank you for coming on Working Capital.
Thanks, Jesse. Appreciate it.